Hello and welcome to this Kids SEND Information, Advice and Support Service video on Refusal to Assess Tribunal Appeals. My name is Zoe and I am a SENDIASS practitioner here in Hull. Please take a look in the description box for how to find your local SENDIASS service. The focus of this webinar will be to take you through the process of appealing a local authority's decision not to assess the special educational needs of a child or young person. We will touch on the different options you have following the local authority's decision, but the main focus will be on appealing to the SEND Tribunal, also known as the First-Tier Tribunal. This webinar will be relevant to parents and carers of children with special educational needs and/or disabilities, and young people themselves if they are over the age of 16. If you have made a request for an education, health and care needs assessment and it has been rejected. We will put relevant links in the description box of this video, so please have a look there for details of your local SENDIASS and further relevant resources. The aim of this session is for you to understand and have confidence in navigating the SEND Tribunal process for your child, or yourself if you are over 16 years old, in relation to education, health and care needs assessment requests. For the purpose of this webinar, I will refer to Education, Health and Social Care as EHC and the local authority as LA. The information in this webinar has been taken from the SEND Code of Practice, the Children and Families Act 2014 and the SEND Regulations 2014. First of all, we will discuss what will happen once the LA has made its decision, as well as the different options that are available to parents, carers and young people. It's important to remember that in terms of the law, when children turn 16 and stop being of compulsory school age, they are classed as young people, and the right to make decisions about their EHCP becomes theirs. They can still have support from a parent, carer or someone else, but the rights transfer over to the young person. Parents and young people over 16 have the right to appeal decisions made by the local authority relating to EHC needs assessments. The LA might decide not to carry out an EHC needs assessment of a child or young person's needs. In this case, it must notify the parent or the young person in writing within 6 weeks of their original request being made. Any formal LA decision letter must detail the decision and why the decision was made, as well as the parent or young person's options and where to find further information, advice and support. It must also detail the parent or young person's right to request to attend a mediation meeting and/or to appeal and the time limits for doing so. You will need this letter showing your right to appeal in order to request a mediation meeting or to lodge an appeal. We will now take a quick look at the options available to parents, carers and young people following a refusal to assess decision, before going into more detail about the SEND Tribunal and how to appeal. There are a few options for parents, carers and young people if you disagree with the local authority's decision not to assess. If you require further information about these options, please do get in touch with your local SENDIASS service. Firstly, you can resubmit your request to the local authority as long as an EHC needs assessment hasn't been carried out in the past 6 months. The educational setting can also resubmit the request if they originally put the request in. It is worth noting that resubmitting your request with the same evidence may result in a similar outcome, but it is an option. You can also request a dispute resolution meeting with the LA to discuss your concerns and find out more about how they made the decision. It is worth noting that dispute resolution is an informal meeting and is not part of any legal statutory process. So although the LA might offer this as an option, it is voluntary and cannot be enforced. This could result in delays in arranging such a meeting. Alternatively, you can request a mediation meeting, and unlike the previous option, this is part of the legal statutory process. This means that if you request a mediation meeting with your LA, they cannot refuse, and they must arrange the meeting within 30 days. This option involves an independent mediator facilitating discussions between parties and supporting parties to reach an agreement where possible. The LA representative attending must have the power to overturn the decision if this is the agreement that is made. They can't say that they need someone else to approve this. Please refer to your decision letter for how to contact your local mediation company. Finally, you can appeal to the SEND Tribunal or the First-Tier Tribunal. Whether you have been to a mediation meeting or chosen to opt straight for appeal, parents and young people over 16 have the right to go to appeal. A parent or young person's rights to appeal are linked to the date at the top of the formal LA decision letter, or a subsequent mediation certificate, whichever is the later date. We will have a look at this in more detail now. So, for example, you will have 2 months from the date on the letter that came with the LA's decision, or 30 days from a mediation certificate, whichever date is the latest, in which to appeal. For a refusal to assess appeal, you must first do what is called considering mediation, which means speaking with a mediation advisor and either requesting to attend a mediation meeting or telling them that you don't wish to attend and would just like your mediation certificate. You never have to attend a mediation meeting if you don't want to, but for this type of appeal, you must obtain a mediation certificate before lodging an appeal. If you attended a mediation meeting and the outcome stayed the same, you would still have your right of appeal and would still need this to register the appeal within 2 months from the date on the original LA decision letter or 1 month from the mediation certificate, whichever is the later date. Now we will move on to how to register an appeal to the First-Tier Tribunal, sometimes called SENDIST. First of all, it is worth noting the legal test that will be considered in this type of appeal. This just means the requirements that must be met in order for an action to take place. For example, the test the local authority should have considered when deciding whether to assess a child or young person's needs is taken from the Children and Families Act 2014. This states that the local authority must carry out an EHC needs assessment if they are of the opinion that the child or young person has or may have special educational needs, and it may be necessary for special educational provision to be made for the child or young person via an education, health and care plan. In other words, is there evidence that the child or young person may have a special educational need, and do they need support that is over and above what can generally be provided in a mainstream setting? Will the child or young person receive the support they need without an EHCP? Therefore, the more evidence you can send off with your application for appeal to document the child or young person's needs and the support that is required, the stronger that application will be. Different types of appeal require different forms to be completed and different paperwork to be sent off. You can find the forms on the SENDISS website, which will be linked in the description of this video. And there is a list of documents you need to send detailed at the end of the form. Please check your local SENDIASS service to see how they can support you with SEND-related paperwork and the process of lodging an appeal. You can either complete all paperwork electronically and email your application to the tribunal, or you can send your application by post. We advise that postal applications are sent via recorded delivery and that copies of documents are sent rather than originals. For a refusal to assess appeal, you will need to complete and send in a SEND 35A form, include a copy of the LA's original decision letter showing the date, the decision, and your right to appeal, Include your mediation certificate. And as previously mentioned, this does not mean that you must attend a mediation meeting, only that you need to contact mediation, consider mediation, and request your mediation certificate. Copies of any relevant evidence, for example, professional reports, diagnosis letters, school reports, support plans that you would like to be considered as part of the appeal. And lastly, please make sure that you check that you have included everything they are asking for, as missing paperwork could result in your application being delayed. Here is an example of the start of the SEND 35A form that you would need to complete, either as the parent carer on behalf of a child under 16, or yourself if you are a young person over 16. You can find copies of these on the Tribunal website under SEND Tribunal forms. Lastly, you can find further information, advice and support by contacting your local SENDIASS service. SENDIASS can provide further information, advice and support around your options, as well as guidance on what type of information you can include in your appeal form. Please check the description box of this video for how to find your local SENDIASS service. There are also plenty of useful resources on the IPSI website, which will be linked in the description below. Thank you very much for watching.